Excellent. Okay, so here's the link. Yes, so here if you can mute yourself, and I'm going to mute myself here, we're going to go ahead and be on the other screen where you can follow the presentation. If you have any questions, feel free to drop them in the chat here or on Facebook, either way.
Is that music on your end or my end?
That's our music.
Okay, like I hear a lot of music.
Yep. Okay. Thank you everybody for joining us on Facebook Live for this really important presentation. A lot of people have questions about the legal and the financial issues that arise with dementia, which is an illness that fundamentally limits the decision-making abilities of the people who have the condition as it advances over time. In the beginning, you start off able to make your own health and financial decisions, but that actually requires some assistance as the disease advances. So today we have a really great guest with us, Kelley Bentley, who is a lawyer in the greater Houston area, who's very generously joined us for this important conversation about the financial and the legal matters in dementia. And we've asked her to share a bit about what is relevant for family caregivers of people living with dementia in particular. We had these 3 questions to kind of frame the conversation today. And then we really want to open it up to anyone who's joined us to ask questions that you may have, trying to keep it kind of mostly general if we can. I know that there are very, very specific circumstances that some people may have, but we will may be limited in our ability to answer those. But generally speaking, I'm sorry, if we could put the objectives up again, we want to cover these topics. Let me see here. Yep. Physical and financial safety when our loved ones with dementia are refusing our help. That is a really huge challenge. And, how can we navigate that? What can we do in advance and while we're going through it to kind of minimize the difficulty with that? The right to pursue right time to pursue a power of attorney, mental health warrants, and guardianship, which are all different things that kind of come into play at different points in this process. Maybe not necessarily all the time. In every case, you might not have to deal with each of those things. But Kelley will hopefully help to elucidate when they become relevant. And then finally, how we navigate disagreement within our families. And when I talk about families, this is also just families that are chosen families as well as blood families, because in some cases we don't have people who are blood relatives, and that itself may actually introduce some legal complexity. So any of that kind of disagreement, how can we navigate that? So yes, thank you very much, Kelley, for joining us. I don't know if there's anything else you'd like to say about your background, your interest in this topic. Go ahead.
No, thank you for having me, of course. Like you mentioned, I'm a board certified estate planning attorney. I'm also a certified elder law attorney. And I've been helping families navigate this very difficult time for about 20 years now. So I've been around for quite a while. And it's a very important topic. And I'm glad you mentioned that everyone has a different journey. Everyone's dementia is different. It affects family differently. There's family dynamics involved. So it's very difficult to say a general, this is what you should do, because even amongst the same family, you go down different paths all the time. What might work for a couple of months may not work, all the time. But in general, there are some things that you need to do in order to be able to plan for a period of time when that individual with dementia no longer has the capacity to act or handle things on their behalf, make medical and financial decisions. I'm going to get to guardianships, but first I want to start with the 5 documents that everyone really needs to plan not only for people with dementia, but for themselves as well. And that would be a statutory durable power of attorney, your financial power of attorney, same document, medical power of attorney that allows a person to make medical decisions for you, a HIPAA authorization that in the medical field, y'all are familiar with HIPAA. That gives people the access to medical information, to talk to doctors, speak to medical providers. And then, of course, you need a will. The will is not really necessary to help while one's alive, but it provides those clear instructions for what happens after someone passes away. So in a perfect world, everyone would pre-plan. Everyone would have these documents completed along with an advance directive directed to physicians. That doesn't happen all the time. And even if it does happen, even if you do the correct planning, sometimes these documents may lack some powers. Specifically in the financial power of attorney, if you need to create a trust, or if you need to speak to Social Security, or if you need to talk to certain financial institutions, they may not accept your financial power of attorney. Social Security does not take financial powers of attorney. So if you need to speak with them, you'll have to become what's called the representative payee. So there's a couple of different hats that family members wear when they're navigating the world of dementia from a legal perspective. So again, your financial power of attorney, medical power of attorney, those are important for anyone that you want to make these decisions on your behalf. So, a big thing happened. I think a lot of people are familiar with these documents. So what happens if you don't do this planning, or you want to do the planning, but it's too late and the person lacks the ability to sign these documents? Well, that's when you're really into a guardianship. A guardianship takes the control away from, it takes the ability to choose from the person with dementia. So if the person with dementia can select who they want under a medical power of attorney, under a financial power of attorney, but once we're into a guardianship, they really lose that control, that ability to decide who is going to make these decisions for me, and the court will appoint someone to make those decisions for them. You are declared legally incapacitated. You cannot vote. You cannot do anything that a person with capacity would be able to do. You can't choose where you live. So all of your decisions, all of your control is given to someone else appointed by the court. And this goes into one of the objectives you mentioned of what happens if people can't get along? What happens if people have different visions of what this type of care looks like? Well, if they can't get along, the court is very rarely going to appoint one of them over the other. So if you have siblings who aren't getting along, if you have a spouse and kids maybe from a prior marriage who just aren't getting along, they don't share the same values, the same opinions, what might happen at that point is the guardianship would appoint a third party. I've seen it happen many times when the family just cannot come to a consensus. They appoint a third party, which could be an attorney, it could be a private certified guardian. It's someone other than the family that's making decisions on behalf of the person with dementia. And that may make everyone unhappy. They may not, at that point, no one wins, because their main goal is to make sure that the person with dementia is taken care of, not necessarily that all the kids' feelings aren't hurt or that the spouse is getting what they want. The main difference I think people don't realize is the cost associated with these. When you're talking about preparing financial powers of attorney, medical powers of attorney, basic estate planning documents, those are usually done at a pretty relatively low cost. These are forms you could even download online or get them relatively easy. A lot of banks have their own form, hospitals have their own forms. When you're talking about a guardianship, you're talking about not only the attorney that's being hired for the person filing for the guardianship, the applicant for the guardianship, the court will also appoint an attorney for the person with dementia. They'll also have attorneys if other people are fighting it and contesting it. So whenever you have that many attorneys involved in any kind of function at all, it's going to be very expensive. Guardianships, if they're contested, if they're fought over, could easily go over $100,000 when it's all said and done about who is going to control this person's financial affairs or in personal affairs. So guardianships, typically you want to avoid them. Sometimes you just can't. Not all guardianships are contested. Sometimes they come about because the person didn't plan. Either they refused to sign a power of attorney while they were able to, or they don't have the capacity to sign a power of attorney anymore. You can start with a guardianship if you don't have those documents, and decisions really have to be made. A lot of people can't afford the cost of a guardianship, but they want to serve as guardian. So what can be done first is you could file what's called an information letter. So an information letter is something filed with we're in Harris County, it's with the probate courts. In smaller counties around this area, it could be filed with the county courts at law, whoever hears the guardianship matters in that county. An information letter will trigger the court to say, hey, I have a person here, and this could be a neighbor, it could be a family member that you're worried about, or even a more distant relative. The information letter just alerts the court that says, hey, this person's in my life. I think they may have some issues, or they can't make their own decisions. Either they have no one visiting them, or they won't go to a doctor, they won't go to an attorney. I'd like the court to investigate. So what the court does at that point is they employ either a court investigator or they appoint what's called a guardian ad litem. It's not permanent. They haven't been declared incapacitated. They're just doing a little investigation at this point. So the court investigator will go visit the person in their home or nursing home or facility, wherever they might be, and they'll say, yes, do you think a guardianship is necessary, or no, we don't think a guardianship is necessary. But if the guardianship is necessary, then they will appoint what's called an attorney ad litem. The attorney ad litem actually files the application on behalf of the individual. At that point, family members can come in and say, hey, look, now that we know there's a problem, we want to be involved, we want to serve as a guardian, and they can kind of piggyback onto these applications that are done by the court, starting from this investigation letter. So a lot of times, if you can't afford to hire your own attorney, you can't afford to do it on your own, the information letter is a way to get the process started without having to hire an attorney and come with a bunch of fees. So, did you have questions at this point, or we just kind of continue on?
Sorry, no, this is like such helpful information. I don't have a question at this moment, and we're monitoring to see if others have questions. So I'll let you know. I'll pop in and let you know on audio.
Okay, so the guardianship itself, that's a good way to start. So an information letter, a court visitor. Now, if there's an immediate danger, if the person with dementia is immediately in threat of harming themselves, or they're in a situation where they have to get out, you can do what's called a temporary guardianship. So a temporary guardianship happens in a very short period of time, but there has to be a very clear, immediate, present danger, either of themselves, either they are, say they're in a home and it's 110 degrees outside, there's no AC, and they don't know to go cool off or whatever. That's an immediate danger. They can be removed from that by a temporary guardian. Another immediate danger would be if they're falling victim to scams. People target the elderly, they target people with dementia. If their estate is at risk of being depleted based on scammers or things that they cannot protect themselves from, then a temporary guardian can happen as well. Now, again, it's temporary. It's only for 90 days. During that 90-day period, the point is to go ahead and get a permanent guardian appointed, go through all the legal process for getting a permanent guardian appointed, but at least temporarily that person can be safe and they can be taken care of in that immediate time of need. You could also contact APS, Adult Protective Services, if you think that someone is being taken advantage of or they're in a dangerous situation. APS could also get involved as well and do an investigation. What happens with APS is they can actually file guardianship proceedings on their own. Now, it takes longer. Usually APS is not quick. Texas Health and Human Services also has a guardianship service as well. Not quick. They always look for family to serve, but they do have their own internal guardians that would serve as guardian over certain wards. Again, it's not quick. It takes some time. But if there's no family, no one available, no one else can serve, then APS and Texas Health and Human Services can step into the role and serve as guardian. I know in Harris County, we have a Harris County Guardianship Program, which is run by the county. They serve as guardian for people who don't have any family or people who are willing to serve or are qualified to serve. Not everyone can serve as guardian. You have to be qualified. You can't be a minor, of course. You can't be a felon. Those are some certain things that would prohibit someone from serving. So if you have only family, and maybe they have a felony back 25 years ago, they wouldn't be able to serve as the guardian of a person or an estate.
I have actually one question that's come in from one of our audience members, which is, what is the distinction between guardianship and curatorship?
Conservatorship?
Maybe that's what they meant.
Yeah. So it's really the same thing. We don't have a conservatorships in Texas for adult people. So some states, they call it guardianship or conservatorship. Usually it's more in the realm of the estate side, the financial side of things, and the guardianship is of the person. It's just different state terminology for basically the same thing. A conservatorship versus a guardianship, very similar. Texas, they're called guardians.
Wonderful. That's super helpful. Another audience member actually asks a question from South Africa. I think it's still very pertinent as a question to address from within the United States as well. This is about power of attorney and whether it holds water after a diagnosis or when it is in effect. Does one require a power of attorney for finances and medical decisions? And what are all of the benefits, I guess, of having that in place?
Well, the main benefit is, you avoid a guardianship and you get to select who you want to serve in those roles. So a financial power of attorney is necessary to do any financial transaction on behalf of an individual. Usually you can make them effective immediately, or you can make them effective whenever you become incapacitated. Usually I tell all my clients, go ahead and make them effective immediately. If it's only on incapacity, it's called a springing power of attorney. So a springing power of attorney means it springs into effect when an individual becomes incapacitated. That's usually documented by two different physicians saying that they are no longer able to handle their financial affairs. In my experience, it's more difficult for banks to accept that, especially if you think you might be getting those letters relatively soon after executing the power of attorney. So let's say you have someone come into your office and they sign a power of attorney. You think they have capacity, but then a month later you get two doctors' letters saying they don't have capacity. Well, a bank's going to look at the dates and go, hey, this is really close to when they signed the power of attorney. Did we really think that they lost so much capacity in a month that they're not able to sign anymore? So I typically tell everyone, make them effective immediately. That way, it's a designation you make on the power of attorney itself as to if they're effective immediately or upon incapacity. It just saves the heartache or the hardship of trying to find two doctors and having a bank accept that power of attorney. Some people just don't want to make them effective immediately, but I always tell them, hey, if you can't trust them when you have capacity, why are you going to trust them when you lose your capacity? Because they have a lot of power. A power of attorney can do a lot of things, especially in Texas. They can sell your real property. They can manage your bank accounts. They can file your taxes. They can apply for public benefits for you. They can do pretty much everything you can do financially. They can step into your shoes and handle it for you. There are a couple of things that a power of attorney cannot do. A financial power of attorney cannot sign a new will for you. Unless you specifically give them the power, they can't change beneficiary designations. They can't change right of survivorship designations unless you specifically allow them to. So again, the benefit is someone that you've appointed is in charge. I usually say appoint someone and have a couple of alternates in case that something happens to your first agent under that power of attorney. You have a couple of alternates after them. But yes, you have to have that document in place to be able to manage anyone's financial assets. And even for spouses, a lot of spouses think that, oh, this is my husband's 401k. I can call them up and just like him, I can get money out of it, or I can manage his accounts that are only in his name. It doesn't work like that. And so, especially for 401ks, IRAs, those retirement accounts, those are individual retirement accounts. A spouse, unless they've already allowed them to speak to the financial advisor or speak to that plan administrator, a spouse does not have automatic access to be able to access retirement funds. But a power of attorney will get you that access. And for a medical power of attorney, in Texas, we do have a list of people who are able to make medical decisions in the event of an emergency. But if it's just a routine medical decisions, going to the doctor, getting information, getting access, unless you have that medical power of attorney signed, you can't get any information at all. Even for kids. So if you have a kid turning 18, that was one of the first things I learned was I was cut off my son's my chart for his doctor because he's over 18. He's an adult now. And the same thing applies for spouses. Now, you may be able to get information for your husband or your parent because you're the one that always takes them to the doctor so they know you. But if you go somewhere new where they don't know you, there's no assumption that you'll be able to get any information or have any say over those medical decisions for them. And again, if you don't have these, then you're into the guardianship situation where you have to have the court telling you what to do. Now, for a married couple, there is a special type of guardianship called a community administration. So if you have a married couple where most of their property or all their property is community property, we're in Texas, pretty much everything you buy after you're married is community property. You can do what's called a community administration. It's a little more cost effective than a full guardianship because once the spouse is appointed community administrator, they can manage all the community property of the marriage. They don't have to have permission to sell property or to access accounts or file accountings every year. It's another thing with guardianships. You have to file an accounting every year of how you spent every dime of that ward's money. All money coming in, all money coming out. You have to account for everything that you do. If you want to sell a piece of property, or if you want to close an account, if you want to open up a new account, everything has to get permission by the court before you do anything. It's kind of like that game Mother May I, if you've ever played that. Mother May I take 2 steps forward? No, you cannot. And so it's like that game there. But with guardianships, it's attorneys involved and court involved and hearings involved, so it just gets expensive.
That's very helpful. Thank you very much. I guess please go ahead.
Sure. Another thing is conflicts. I know that was one of our objectives, is what happens when people don't get along. And it's one of those unfortunate situations where all roads sometimes point to guardianships. So let's say, take for example, let's say you have an individual, a mom and a dad. Let's just say mom signs a power of attorney and everything is going along fine. Dad passes away, but mom has her power of attorney. One of the kids is named in the document. Everything's going on fine. Then another one of the kids is like, hey, mom's bills aren't being paid, or I don't think that this sibling is taking care of mom the way that she needs to be taken care of. Even though there's a power of attorney, that power of attorney can be abused, and this other child thinks that, hey, mom is just not being taken care of. That other child can file a guardianship as well. So just because you have a power of attorney doesn't mean that you can be completely cut off from finding out what's going on, making sure that mom's being taken care of, making sure that that power of attorney is doing the right thing. Unfortunately, most elder exploitation, abuse happens by family members, happens by people with a power of attorney. So it's unfortunate, but that access sometimes, not all the time. It's not necessarily, an evil. They think, oh, I'll just borrow some money, I'm going to put it back. It snowballs that way sometimes. But if that happens, typically you're back into a guardianship situation. And usually the person serving as the power of attorney is not going to be eligible to serve if they've been doing bad things with the person's money. That child may not be able to either because they object to them serving. They don't want them serving as well. Then you're looking at a third person. Having a third person is not necessarily a bad thing sometimes. If you just have a family where people just cannot get along, that third person either, again, it could be an attorney. We have private certified guardians in Texas. Over the person, it could be one of those two people. They'll make decisions that the family just can't. They can't agree on. So the needs of that person with dementia are always paramount. They're always the primary focus of any guardianship. With regards to the estate, sometimes you could do what's called a court-created trust. In Texas, it's a 1301 management trust. That's the name of it. But it's a court-created trust where a bank serves as the corporate trustee. Usually for those trusts, it can't be a family member. It'll be a bank or a third party. And they'll step in and make sure all the bills are paid, the money is protected, invested properly. So those are different types of arrangements that can be made if the family just cannot get along, which happens all the time.
I have actually a question about this with respect to like cultural fluency for people who get appointed to help manage the affairs of people who have dementia when there is this kind of internal conflict within the
Mhm.
folks who would otherwise be caring for that person and ideally aligned in how to care for that person.
Right.
So when you have these third parties step in, some of what I have heard in different advocacy spaces about having APS or, sometimes in this case it's APS or adult protective services, but I've also faced this with protective services. Um, there is a lack of cultural fluency, right? And a
Mhm.
lack of kind of tailoring to really the values of the people involved, of the principal person who is impacted. How do you deal with that? Like, yeah,
Yeah. I mean, it depends on the person that's serving. I know in Harris County, I can speak to Harris County probably the best, which is where Houston is, but the court tries very hard, especially if there's language barriers, to make sure that someone from that culture is the one appointed as the guardian or that person. A prime example is I had a client, they were Vietnamese, um, and in the Vietnamese culture, I learned mental health is really a stigma. They do not like to talk about mental health, dementia. It's just very, they don't like it. The lady that we were getting guardianship over, she desperately needed it. I mean, she needed a guardian. She had two kids who were lovely. They got along great. She did not want to turn over control. She did not want to do anything, but she desperately needed help. The attorney ad litem they appointed and the guardian, the kids were the guardian, but the attorney ad litem and the guardian ad litem were both Vietnamese. They spoke her language. They could communicate with her. They knew where she was coming from. They knew where the kids were coming from. So it was very helpful. When you're in a city like Houston that's very culturally diverse, usually there's hopefully for the dominant groups of people, there's attorneys that specialize in this area that could help assist and help advise the person. I think it's when you get to the smaller counties that may not be as diverse as a big city, is you have that problem, and sometimes there's a conflict even with the person serving and the family. They have that conflict. They don't, and they're ultimately they're going to do what they think is best for the ward, and it may not align culturally.
okay, great. That's super helpful. Thank you.
Yeah. Um, what else would I like to talk about? I mean, I kind of went over the legal side of things. I mean, is there anything else I didn't cover that you think would be helpful, or that
Um,
there's questions?
yeah, let me see if there are any other questions coming in. I'm trying to think. I have had in the past like so many questions about about legal and financial matters. I guess another one is, so I've had some like kind of differences of opinion that I found about whether to do the power of attorney on your own, and whether to get an attorney to actually do it, or whether to draft one on your own and to have an attorney review it, or I'm not sure like what you would advise, but I think it would be helpful to know like maybe the advantages and disadvantages of doing it. Like, as you mentioned, you can print out a template online, right? And that's probably
Yeah.
going to be a lot less expensive than
Yeah.
have an attorney do this for you. So yeah, if you can maybe go over that a little bit.
Yeah. I mean, all these documents, the financial power of attorney, the medical power of attorney, those are all forms. There's actually a form in the text of the state's code for these documents. If that's what you can do, then I would say yes. If all you can do is print one out or get one from your bank, what you're missing out on is the legal advice. So the form doesn't have everything that is necessary for the medical power of attorney is really not as complicated as like the financial power of attorney. So the financial power of attorney, there are certain things that have to be initialed, signed a certain way that enable the agent the power to do what they need to do. And I'll give an example. So as an elder law attorney, I do a lot of Medicaid planning. So a lot of my clients are going into nursing home or they want home-based Medicaid. We do a lot of Medicaid planning. And the number one document that I'm constantly redoing is the financial power of attorney. And the reason is if you print out the form online, you're going to get a very basic form. Hopefully you get a Texas form. Sometimes you get a form from another state. It's a very, easy, readily available document. But the problem is the agent needs the power to do certain things for Medicaid planning usually. Sometimes you have to create a trust, whether it's a Miller trust for income or a trust to hold assets or to transfer. The financial power of attorney on its own form, does not give the agent the power to create a trust and to move money into a trust. It also doesn't automatically give the power to make gifts. And so usually for Medicaid, gifting is a no-no. But if you're talking about gifting to a child with a disability or making allowable gifts, if your agent under the power doesn't have that power, you can't do it. A very common strategy that we use is creating college savings plans for kids, for grandkids or nieces, nephews, great nieces, nephews. Well, if your agent doesn't have the power to make gifts, they cannot create those college savings plans. And so there are certain things, specific items that an attorney would look for and add and make sure they're there that you may not get on a form that you print off online. That's really the only difference. It's that counsel, it's that advice that you get.
That makes a lot of sense. You brought up something else that comes up very frequently with a lot of the caregivers that we work with, because we tend to work with lower income caregivers, and that is about Medicaid. I know that in states like Texas, where we have not expanded Medicaid, very few people will qualify. But where it has been expanded and or where you qualify, there are lots of benefits that you can get as a caregiver of somebody living with this disease. I guess, how would you advise people if they're trying to qualify for Medicaid? Like, what should they be thinking about and how much in advance?
Well, I always say when you're first diagnosed with dementia, before you even need care, let's look at how you're going to finance that care moving forward. And so if that means that potentially even in 5-10 years, care is expensive, either home-based care and a memory care and assisted living, it's expensive. A lot of people cannot self-fund that level of care that they need. So I always say the earlier you start planning, the better. So typically a client of mine will come in and say, hey, we were diagnosed with dementia or whatever it might be. Let's get your powers of attorney. That's always your first step. Are your powers of attorney, is all that done and executed? If it all is, that's great. Let's look at your assets. So there are certain assets in Texas that don't count against you for Medicaid eligibility. There are certain ones that do. So if we have enough time to say run out a 5-year look back period for the transfer penalty, or to shift assets around, to move things around to preserve for the family, whether that's in trust or out of trust, depending on every situation is very different. But if we want the ability to make transfers and wait out a 5-year look back period, because there's a penalty period for Medicaid. They look at all transfers less than 5 years. And if you do a transfer less than 5 years, they're going to penalize you. You won't be eligible for benefits. But if we have that 5 years to make those transfers before we need the care, a lot of times we could shift a lot of that wealth outside the family, and by the time they need Medicaid, they've already gifted in, shifted out all that wealth away from them. So a lot of people, though, they don't start that pre-planning with enough time. So we're caught in a situation where, okay, we have maybe 6 months of care left. What do? We don't have any money left. Texas, we didn't expand Medicaid. It doesn't cover memory care. It doesn't cover assisted living. There is a home-based Medicaid program that would help caregivers who are living at home, but Medicaid just doesn't fund the type of care that most people with dementia need until they get to the point where they need nursing home care, and then that care is usually funded.
Yeah, just for people listening, to clarify, Medicare, right, will not cover nursing home. The cost,
a very limited benefit,
right? The cost of a nursing home, that overwhelmingly that's going to be covered by Medicaid. And so if you don't qualify for Medicaid, and that is something that you are willing to explore, I know for a lot of families, it's kind of off the table. They're not going to put their loved one in a nursing home. They're going to do all of their care at home, however difficult that is going to be for them at every level. But for those who want it as an option, it's really important to think about how you will or can qualify for Medicaid as early as possible for the reasons that that Kelley Bentley has described here. Going back to power of attorney, because Joel, one of our audience members who's joined us, had this question. And I also actually had a follow-up question to his question. So his question is, he says 2 physician signatures did I understand that 2 physician signatures or letters attesting to a person's mental incapacity are required to invoke a power of attorney? There's the first question, and then I'll follow up.
Okay. If you have that springing power of attorney, where you have a power of attorney that's only effective upon incapacity or disability, then yes, typically it's 2 letters. Sometimes the power of attorney changes that, so you have to read your power of attorney document where it talks about when it's effective. They always have an effective date on there. But usually, typically, if it's silent, it's 2 letters, 2 statements from a physician saying that they no longer have capacity. Okay.
Okay, great. And the question that I had to follow up is is there a requirement for who these physicians are in terms of their specialty, in terms of their, just like competence in certain areas of medicine, or no?
No, just 2 people who are familiar with the principal, the person who signed the document. It can't just be like the neighbor down the street who's never examined her. It needs to be from her physicians.
I see. Okay. And is there any specific language that needs to be used in that documentation of capacity in terms of like when we learned about it in school or in training, it was like these 4 different aspects of capacity, right? That you can understand, that you can reason, that you can appreciate, that you can communicate your decisions. Does it need to be documented in exactly that way, or is there a specific thing that you need to say?
No, I mean, I've seen letters that just say, it's my opinion that whoever cannot manage their own financial affairs.
Okay, got it.
It could be that brief and short. Now, if you're pursuing a guardianship, there's actually a form the doctor fills out about what their opinion is on their abilities. So it's like a fill in the box, check the box form that has to be completed. That's different for a guardianship, but for a power of attorney, usually it's enough that I believe they cannot handle their own finances.
Got it. Yeah. That's also something that I think often people misunderstand, is that like assessments of capacity are really specific to the decisions that people are making, right? So I think it's come up now, this is not pertinent to the decisions we're talking about here, which are really health and financial decisions, but it came up in one of the support groups that I'm in, also as a support caregiver. I'm seeking support. The question was about voting, actually. Like, when do we discontinue that with our loved ones, right? And it isn't something that is so easy to say, because it's not like because you have a diagnosis of dementia, you automatically are incapable of voting. That's not true, right? It's like, it's a very specific thing that if you're still able to do that in all of those ways that we described, then you should still maintain the right to vote.
Right. Even under a guardianship, that's one of the rights you can maintain, is the ability to vote. And typically what the courts will say is, are you able to make your own independent decision, looking at all the facts of who you'd want to vote for? And if they can make that independent decision and not be influenced or swayed by other people telling them what to do or who to vote for, then they can keep that right to vote. Yeah, because legal incapacity and medical incapacity aren't necessarily the same thing. So unless you've been determined legally incapacitated, you can still make poor decisions and drive and do all those things, but maybe the power of attorney might trigger in. Even if you have dementia, you can still do a will if you have a lucid moment where at the time you signed, you knew what you were doing. Now, the more severe dementia is, and if you have a lot of doctors saying that you don't have the ability to do these things, will these documents hold up in court if someone can test them? Maybe not. I mean, very unlikely, no, but, in a pinch, it might be what you need to do.
That's very helpful. From your perspective, are there any big things on these topics, right, on legal and financial affairs and dementia, that we really haven't covered here, like in terms of what you typically talk about with your clients or in other educational settings?
I mean, no, usually we focus when we're talking about this area is, your financial power of attorney, medical power of attorney, all those documents that help appoint someone else, and then a guardianship. I mean, guardianship to me is what you want to avoid. Those are really the 2 things that can help someone else make a decision for that person. So if you're looking at who's in charge, who's steering the ship, that's how you get there. You get there by appointing a financial power of attorney, or if you don't have that, you're into a guardianship. There are some other kind of lesser known ones. So if all the person's receiving is, say, a Social Security, you can become the representative payee for that person. To where maybe all they have is just Social Security payments, and they don't need a guardianship, but they need just someone to receive those payments and make sure their bills are paid. That's something through Social Security that can be done as well. It's really is who has the ability to be in charge and make decisions with different groups of people.
It doesn't come up often, but it has come up before with some of our caregivers that their loved ones with dementia are really like either neglecting themselves, or they are to where it is a threat, a health threat to themselves, or they're engaging in a way that can be potentially dangerous to other people, and they really are seeking some kind of like urgent intervention. So what of these things that you've mentioned, or maybe it's this mental health warrant that I mentioned at the beginning, what is it that they can kind of utilize in order to get help in an urgent setting, right?
Urgent. If it's an immediate, if we don't do something right now, they're going to harm themselves immediately, you could do a mental health warrant. A mental health warrant can be very traumatizing for the person going through it, because they'll be picked up and they'll be taken into the system. And so they'll be placed in facilities with people who may have severe mental health issues. They'll be appointed an attorney, and it's usually for a period of time they'll be in that facility. Sometimes that's necessary. I've had to do that for clients whose medication was completely off. Like they were just their medication was not working for them anymore, or they were forgetting to take it. Maybe it's the wrong prescriptions, wrong doses. We've had to have people involuntarily committed for a certain period of time to get their medications in order. Usually go to a geriatric psychiatric, a geri psych unit, and they'll get those medications in order. Then they can transition to like either a hospital or a facility, or even back home at that point, once their medications have been regulated. Another of the immediate need would be the temporary guardianship. The temporary guardianships usually take about a week or so, sometimes quicker, to get them in place. So a temporary guardian is another alternative as well. So either one of those would be immediate, like right now something bad's going to happen, it would have to be the mental health warrant. But if you have like just to remove someone from a danger, you have a couple of days to do it, then the temporary guardianship would be the way you want to go.
Where I know that this is very kind of privileged, it's something that we do have access to as kind of a new pilot program in Harris County, although I know recently we've had some issues with how that program has been financed. But some cities do have, or counties do have a team that is related to their law enforcement, right? That they actually will deploy instead of law enforcement, so unarmed, where they have, social workers and other allied health professionals who are engaged in the community with people who may have dementia or who are otherwise behaviorally, a danger to themselves or to others. Right. How does that come into play in all of this, I guess?
Whenever you make the call that, hey, we have to have someone come out here, you request that particular unit of people to come out there instead of the police officers. Now, 9 times out of 10, that unit is very busy. And so you're going to get just a regular police officer at first, and it may take several calls to get that specialized unit to actually come out to the scene. So when they're there, it's wonderful because you can talk to a social worker. They're specifically trained. They'll put the person in the correct environment. They'll do the right thing for them. But until they get there, you're just getting a regular police officer. You may not have all the training that the specialized unit will have.
Do interventions like this, do they actually inform any action that you take further? Like, so if you, in addition to this or following this, you want to pursue a mental health warrant or the temporary guardianship, or does it like build a case for these kinds of things, or yeah?
Well, the mental health warrant will happen once they're picked up. That's what's gonna happen for them. They're gonna be in the system. It'll help the guardianship, the temporary guardianship, moving forward.
Got it. Okay.
Temporary guardianships are very difficult to get. They're not easy. You have to be in some type of crisis, immediate danger. Otherwise, the court wants you to take. There's really a move away from guardianships in Texas. People don't like them. The courts don't like them, and they're not pretty. They take away all your rights. They basically, take away all your ability to do anything for yourself. So that they're very difficult to get sometimes, and they don't like the temporary. Another option could be under the state's code is what's called a supported services agreement. I've never really done them. I think it was dreamed up by someone who has never really been in this world of guardianships. But a supported decision-making agreement allows a person to appoint someone to just help them make decisions. So like if they're, it's kind of like a helper. So they're going to the bank or if they're going to the doctor. It's been around for about 10, 15 years or so. I've probably only done it once, and it was for a child who had disabilities that just needed some help from her parents still, but she couldn't sign a power of attorney or anything. I don't know how much weight or teeth they would have, but if you have someone who's not agreeing to sign a power of attorney, I doubt they're going to sign a supported decision-making agreement.
Right.
So they're not really very helpful, but they're available if someone will sign one.
Yeah, yeah. It's so interesting to me because I feel like a lot of the difficulty with this disease is actually inability to communicate effectively with our loved ones who have it, right? Like to understand really what is happening to them in their own heads and what their concerns might be. And then people are reactive, and it's hard to, I think, also escape from whatever baggage may exist relationally with that person.
Yeah.
And now they're changing in a way that's really, it's challenging for all of us, who have to deal with it. Yeah, and so unfortunately, I think that's what leads us to resort to like, well, we're going to have to take like some kind of legal action here, and like,
yeah. Well, and a lot of times they become paranoid too. They feel like people are out to get them, and their kids are going to take their money if they sign these documents. They don't want to turn over that control, that power to them, so they're losing their power. They just don't want the power.
Right, of course. Yeah, no, I mean, this is where I think it's helpful to be in conversation with lawyers, because I think we definitely can try to help the families like learn the communication skills to try to resolve these things without that kind of external intervention. Although the power of attorney, I think ultimately is going to be helpful for everybody. Like, I think that's something that
everyone needs that. Yes.
Yes, absolutely. But some of these other things like mental health warrants and guardianship, like the things that you're talking about wanting to avoid, I think those things are avoidable. Like if we learned some of these skills, if we like really understood what we were dealing with as caregivers to people with this condition, but it's hard. It's really a challenge, and I think that's why we have to be in, like I said, in conversation with our legal colleagues to be able to use those avenues when we need them. Yeah, I think that is maybe all from our audience. I wanted to maybe just kind of close with a thank you to everyone who's joined us today, to Kelley for being here and answering our questions. Again, this is something that I think people don't pay enough attention to early, when admittedly it is very emotionally overwhelming and practically overwhelming to think about all the things in advance. We try to do what we can at PrognosUs to like walk people through what this is going to look like over a period of many years in a way that's super digestible and just kind of hand-holding. So, hopefully that helps. But yeah, thank you to everybody. And yeah, I don't know, Kelley, if you're available in the future, we probably would like to continue to work with you in an educational capacity and otherwise.
Anytime. I enjoy being here.
Yeah. Thank you very much. And if anybody wants to contact Kelley, her information is right here for her website, as well as her email address and phone number for the office. Kelley, is there anything else that you want to say to close?
No, I mean, I just think that everyone who's a caregiver, it's a hard job. Do the best you can, and I know it's difficult. I appreciate how difficult it can be for people in that situation.
Yes, thank you all for doing that work as caregivers, because I think it is a thankless job.
It really is.
It really is. Yeah. Thank you, Kelley, for all of the work that you do as well.
All right. Thank you. And anything else, let me know.
Okay. Sounds good. Bye-bye.